Let's continue our discussion of the judiciary. We have a dual court system, the federal courts and the state courts, an example of federalism and dual federalism when the country was founded. Federal government looks at, in their courts, federal questions, federal crimes, what are called diversity of citizenship cases where you have two citizens from two different states who are maybe suing each other. Those are the purview of the federal court system. Federal court system will also take appeals from regulatory agencies, the bureaucracy, when a question on appeal has to do with an interpretation of the Constitution. And the Supreme Court hears cases involving two different states. For example, if Wyoming should sue Nebraska over state water rights on the Platte River. Appeals to the Supreme Court come from two stations, one being what's called a writ of certiorari, better known as a cert, whereby somebody asks the court to hear a case because they feel it has a substantial constitutional question. If 4 of the 9 judges agree that it's a federal question, then the case will be heard before the Supreme Court on a cert. More than likely, you'll have cases that are asked to be heard by the Supreme Court because they've come from the lower federal courts of appeals. But most of the time, the Supreme Court will reject writs of certiorari, will reject appeals from the courts of appeal because they simply don't have time to hear all the cases, and they're going to prioritize which of those are a substantial question on the United States Constitution. How do you get to court? One way is by fee shifting, whereby states can ask the federal government to hear a case. Federal government looks at it as being a constitutional question, and you'll have the federal government then ends up hearing the case. Standing to sue, you have to have an actual controversy involving a federal law and or the United States Constitution. You have to show that there was personal harm demonstrated. In other words, the courts aren't going to hear hypothetical cases. And the government, the United States government, has sovereign immunity. You can't, in all actuality, you cannot sue the United States government because you'd be suing we the people. Another way you can get to court is by class action suits. A good example is Brown versus Topeka in 1954, whereby a case was brought on whether or not the state's laws on allowing discrimination based upon race were constitutional. That, of course, the federal government struck down its earlier ruling from the late 1800s in Plessy versus Ferguson. Supreme Court, when it decides to hear a case, will hear oral arguments by the lawyers for both sides. Then the 9 justices will ask questions of the lawyers who bring the case to them. The Solicitor General is the person who's in charge of bringing the United States government's case before the court. And what you will have is just a load of what are called amicus curiae briefs, friend of the court briefs, whereby they'll be read into the record. The justices will read them. These are organizations, special interest groups that feel that they have an interest in the case, and they'll file these written briefs before the court. After the case is heard, the justices in secret go back into their chambers. The Chief Justice is the presiding judge in arguing the case. When they finally make a decision, it can be a 5-4, 6-3, 7-2, 8-1, or a unanimous 9-0 decision, which certainly doesn't happen very often. But they make a decision on who is going to have what they consider to be a proper interpretation of the Constitution. You can have a unanimous decision, in which case the Chief Justice will write the opinion. You can have a majority decision. If the Chief Justice is a member of the majority, he or she will write the opinion, which becomes the interpretation of the Constitution. Other justices may concur with the majority of the minority, but for different reasons, and they can write their own opinion. And then you have dissenting opinions, which the judges in the minority can write, which oftentimes become fuel later on for trying to overturn the decision. Blocks are predictable on the Supreme Court when they're making decisions on interpretations of the Constitution. You have those liberals, primarily who have been appointed by Democrat presidents, who believe in an activist court. The court has the right to make decisions which may overturn previous decisions and actually are making legislation. Then, of course, you have the conservative bloc who believe in a strict constructionist view of behavior of the court, and they look at the interpretations based upon the original founding documents. Then, of course, you have swing blocks, those that can go either towards activists or towards a constructionist viewpoint. Power of the courts to make policies by interpretation of the Constitution. More importantly, are points of stare decisis or precedent. Stare decisis means to let the earlier decision stand, and in that way they make an interpretation of the Constitution. If they are making, and they always try to, the court always tries to look at precedent from before. So, in other words, the courts, through stare decisis and precedent, do not like to overturn previous decisions as a means of stability in the United States Constitution. The court in the last 10 years has been more willing to decide political questions, which it wasn't up until about 1995. A good example is in the Bush versus Gore decision in the election in 2000, the court was willing to take on a political question and look at elections. Judicial activism is the idea that the court can be activist instead of constructionist. It can be active in changing the idea of law in the United States by its decisions. Those that are in favor of activism look at the courts of last resort in correcting injustices. For example, the civil rights movement in the 1950s and 60s. Others look at, that are against activism, that the courts have no business legislating. That is the job of the Congress. If policy needs to be made, it does need to be made in the courts by judges who are not elected. It should be done by the Congress. Regardless of how active the court is, there are checks on judicial power. Presidents can refuse to enforce. It has happened. Under Andrew Jackson is a good example. Thomas Jefferson, as president, refused to enforce some of John Marshall's decisions. Hasn't happened very often in the last few decades, but the president can't refuse to enforce judges' decisions. The Supreme Court has no means by which to enforce its decisions. Congress can alter the composition of the judiciary, can change the number of judges, can change what the judiciary is allowed to hear in its courts. Congress can confirm Supreme Court and federal court appointments, and they can impeach federal judges. In our history, there's been 4 federal judges who have been impeached. They can revise legislation that's been declared unconstitutional and thereby make it part of the Constitution through the amendment process. And there would be those that would argue, for example, in the recent decision in FEC versus US, where the Supreme Court decided that there was unlimited funds available for campaign contributions. That's looked upon as possibly being the next constitutional amendment to overturn that decision.